of the Supreme Court, the judges of the High Courts, our invited distinguished guests, ladies and gentlemen, good morning. It's just a wonderful day. Once again, the Lord has given us to continue with this program. We are 5 minutes now, and at this moment, allow me to invite the chair of the session this morning, Honorable Mr. Justice Professor Ibrahim Hamis Juma, the Chief Justice of the United Republic of Tanzania, to come and take up a seat. My Lord, you're most welcome. Let us welcome him with a hand clap to energize him this morning. And my Lord, I take the honor to hand over the morning session. Thank you, my Lord.
A very good morning to you all, Honorable Chief Justice of Uganda, Honorable Chair of the Forum, Chief Justices, judges, magistrates, and all parties. I have the honor of being your chairperson today. Yesterday, I think we left with a keynote address where the theme is still enhanced access to justice. And yesterday, we were underscoring the reforms in the African judiciaries. And we were very, very ably led by Tim Bisong, country director from the Gambia, who gave us a very, very exciting keynote speech. Today, we are going to focus down, to narrow down. The theme is the same, but we are going to land on specialized courts across our jurisdictions. And to help us unpack specialized jurisdictions, we have 6 very, very able speakers. I will introduce them as they come forward one by one. Honorable Lady Justice Polo Philomena Banyane of the Land High Court of Lesotho. If you can give her a clap or two. She's going to lead us to give us an overview of land high courts in Lesotho. In 2005, Lady Justice Banyane obtained her LLB from the University of Lesotho. In the judiciary of Lesotho, she climbed through the magistracy until 1st May 2019, when she was appointed acting judge. She became a Pune Judge of High Court of Lesotho on 2nd September 2020. She serves today in Land High Court of Lesotho, and she has agreed to share with us an overview of the Land High Court of Lesotho. Second is Lady Justice Susan Okalany. Lady Justice Susan Okalany. I hope I pronounce your names correctly. She's a High Court judge, currently the deputy head of the International Crime Division of the High Court of Uganda. Now, the International Crimes Division of the High Court of Uganda is a specialized court dealing with international crimes, transnational crimes. Since Justice Okalany's elevation to the bench in 2016, she has handled complex criminal and civil cases, as well as appeals. She brought to the judiciary of Uganda her 17 years of experience from the Office of the Director of Public Prosecutions, where she served across several districts, and she played a leading role in restructuring the Department of Gender, Children, and Sexual Offenses. She also played a leading role in developing resource materials to improve access to justice for survivors of gender-based crimes, including the handbook for the Directorate of Public Prosecutions on prosecuting child-related and SGBV cases in Uganda. You can see the wealth of our bio and the richness of our discussions, which will come after our presentation. Lady Justice Okalany will cover the topic gains of the International Crimes Division in Uganda. The third is Lady Justice Charlotte Wezi Malonda, Commercial Division, Malawi. She's going to discuss overview of the Commercial Division. She is an accomplished Malawian lawyer with over 10 years experience at the bar and work that directly uses law to achieve social justice. She has also been executive director of the Competition and Fair Trading Commission. She has been involved in law reform initiatives for the competition and consumer protection law within Malawi. She obtained her LLB from University of Malawi, master's from the University of Zimbabwe. She also studied at King's College London, LLM from Loyola University in Chicago. She also brings richness in her discussions today. The fourth is Mr. Justice Esmeraldo Matavele. Mr. Justice Esmeraldo Matavele. He's going to cover the topic juvenile court in Mozambique, its organization and functioning. He obtained his Bachelor of Law from the University of Eduardo Mondlane in 2009, Master of Law from the University of Eduardo Mondlane, 2023, School of Journalism, 2007. His work history is also rich. Professor since 2000, a soldier from 2002 to 2004, a journalist from 2004 to 2009, law clerk from 2009 to 2014, and he has been a judge since 2014. So you can see the richness which he brings to our discussions today. Another speaker will be Honorable Justice Evaristo Pengele from the Economic and Financial Division, the High Court of Zambia. He has worked for quite some, before he became a judge, he was working as the legal and prosecution officer at the Anti-Corruption Commission Zambia. He obtained his LLB from University of Zambia 2005. He worked as a senior legal and prosecution officer of anti-corruption. He later joined the Judiciary of Zambia as a registrar for the Supreme Court. And I'm sure he also worked for quite some time for the forum in the Secretariat for several years. The history of the forum is rich in him. So we are going to gain a lot of experience from his discussion. Honorable Mr. Justice Gichero. Honorable Mr. Justice Gichero. Mr. Justice Gichero obtained his LLB from the University of Nairobi, postgraduate diploma from Kenya School of Law. He has a wealth of experience in the legal profession. He has climbed all the ladders in the magistracies. He was appointed Environment and Land Court Judge in 2021, and his bio is very, very rich. I hope at the end of the day, when we publish the proceedings of this conference, we are going to look at their very rich biographies. I wonder if there is anyone I have missed. Are you 6? We are complete, and I'm sure you're ready. Now back to the responsibility of the chair. It's management of time. We have 90 minutes. Each speaker will have 15 minutes. And whenever you see me raising my hand, know that you still have 5 minutes to go. So I will let the topic flow, and I will only urge members of the public, participants, to take down note of the discussions so that we have very, very live discussions, taking into account not only the topics which they have presented, but the richness of their CVs, which give us a lot of areas for us to touch. So let me begin by inviting Honorable Lady Justice Paulo Banyane to speak for 15 minutes, please. You're most welcome. Okay. I've allowed her to sit so that all of you could see her.
Distinguished guests, ladies and gentlemen, good morning. I have been introduced. I'll try to run through my presentation as quickly as I can so that I confine myself to the time allocated. Let me start off by saying it is a humbling experience for me to have been entrusted by the Chief Justice of the Kingdom of Lesotho with this mammoth task of addressing this distinguished forum. In the same vein, I wish to thank the organizers for this opportunity. This presentation gives an overview of how access to justice is enhanced through simplified court procedures in the Land Court of Lesotho, which is a specialized court dedicated to expeditious resolution of land disputes. The first part of this presentation provides a brief background, highlighting events that informed the establishment of this court. I also highlight the parameters of the court's jurisdiction as well as its composition. By way of introduction, let me indicate that Lesotho is a relatively small-sized country of about 30,355 square kilometers with a population of 2.3 or about 2.3 million. Due to its small size, Lesotho's land is a scarce resource, exacerbated by the fact that 75% of the land area is mountainous and unsuitable for crop production. Taking into account Lesotho's colonial history, land, its control, ownership, and use are significant and sensitive issues for the Basotho people. I'm coming now to the adjudication of land disputes. Before the year 2010, land disputes were adjudicated by the Land Tribunal established by the Land Act of 1979. This tribunal was centralized in the capital city, Maseru, and its jurisdiction was limited to certain disputes. Because of these limitations, land disputes were sporadically instituted in different courts, namely the High Court, the Magistrates Court, and the Basotho courts, commonly known as the local courts, depending on the nature of relief sought by the suing party. Consequently, the country experienced delays in disposal of land disputes. In 2010, fast forward to 2010, the Land Act of 2010 was promulgated, repealing the Land of 1969. This 2010 Act introduced significant reforms to the Lesotho land tenure system, chief among which was secured titles to encourage Basotho to develop their land and use it as an economic asset to reduce poverty. Considering this transformation to the land tenure and the existing impediments to the timely resolution of land disputes alluded to above, one of the objectives of the Act was to expedite resolution of these disputes. And to achieve this objective, the Act established specialized land courts, namely the Land Court and the District Land Court. These courts have exclusive jurisdiction to hear and determine all claims and disputes concerning title to land, derogation from title, and interest overriding title. District land courts are available in all 10 districts of Lesotho. The Land Court, being the division of the High Court, is in the capital city, Maseru. I'll quickly highlight the jurisdiction and composition of the court. The Land Court is composed of 2 judges assigned by the Chief Justice. I'm one of them. The court is conferred with original civil jurisdiction, appellate civil jurisdiction, and review jurisdiction over the decisions of the District Land Court. It has no criminal jurisdiction. I'm now coming to the core of my presentation, which covers the rules of practice and procedure in this court. The Land Court rules of 2012 govern the practice and procedure in the Land Court. These rules underscore the accessibility of justice, the affordability of judicial services, expedited hearing of cases, and informality of legal procedures. There are innumerable ways through which these rules foster accessibility of justice for all people, expedite hearings, and shorten the litigation process, thereby reducing the time lost to both parties involved in the dispute and the legal costs. They are as follows. The litigants are permitted to appear before court in person or through their duly authorized representatives. This can be a party's family member, including a spouse, a child, brother, sister, and parent or guardian. 2, these rules are user-friendly, clear, and easy to read and understand. 3, a person without sufficient means to pay prescribed court fees can apply to court to sue as a pauper. 4, there are limited sets of pleadings filed in this court. I'll come to this aspect later in more detail, if time allows. 5, technical procedural steps that often prolong the litigation process and increase costs are disallowed in this court. Conversely, the rules promote the hearing of the merits of the dispute. For example, setting aside certain steps as irregular is not one of the procedures envisaged by those rules. Lastly, and importantly, the rules reflect a major shift from the traditional adversarial case management, which had left the pace of litigation primarily in the hands of legal practitioners. They transfer the responsibility for case management from litigants and their legal representatives to the court. They substantially increased the judicial involvement in the management, supervision, and control of these cases before court from the pre-trial stage to completion. To expound on the practical application of these rules, I highlight the following procedural steps, which would be the pleadings that are filed in this court. Action proceedings in the Land Court are initiated by filing an originating application. This application does not need to be accompanied by an affidavit, but must concisely state material facts, circumstances, and other relevant matters on which the application is based. The respondent reacts by filing an answer within 14 days of service of the originating application. And to avoid the prolonged discovery of documents and to ensure that both parties are fully informed about the case they have to meet, these 2 sets of pleadings, that is the originating application and answer, are accompanied by a list of documents on which the parties rely for their claim and defense respectively. Moreover, the parties must attach certified copies of documentary evidence in their possession. Where a party seeks to rely on a document in the possession of another person, the party must indicate this fact. If a party intends to call witnesses at the hearing, they must attach a list of these witnesses and their particulars. The purpose for which these witnesses are to be called must also be stated in terms of the rules. A reply is filed only if the respondent's answer contains new facts that are relevant to the issues in dispute. I also wish to highlight the aspect of the judge's involvement in the litigation process. In terms of these rules, the judge plays an active role from the early stages of the case. He is involved in the planning and managing of the case through a series of procedural steps and scheduling of hearing dates. For instance, amendment of pleadings and requests for additional particulars are made under the court's supervision because a party intending to take such steps must first obtain permission from the court. Moreover, applications of this nature to allow flexibility may be made orally if the judge permits. Another process through which the court is then involved is what we call a preliminary hearing. Within 1 month of the service of the originating application, the court must hold the first preliminary hearing referred to as the first hearing. This hearing enables the judge to familiarize himself or herself with the case at an early stage, conduct an early examination of the parties and their respective cases, ascertain both the admitted and disputed facts, identify preliminary issues, and detect the potential for settlement. At this hearing, the court must give directions about the further conduct of the case. The court must fix the trial date if there are no preliminary issues. But where preliminary issues are raised in a special answer on grounds perhaps such as lack of jurisdiction, res judicata, or other permissible grounds, the court appoints a date for the hearing of the objection and if necessary may allow the production of evidence as may be appropriate for the decision to be made on the objection. After the preliminary objections have been decided, the court must then proceed to frame and record the real issues and dispute. I'm moving towards the conclusion of my presentation. Just to sum up the trial procedure. Concerning the conduct of trials, the rules cover all the necessary steps in a trial from commencement to completion. They indicate which party is entitled to begin, how the trial should commence, the manner and order of producing evidence and calling witnesses, the form of questions allowed at all stages of trial. For example, when leading questions may be asked, also directs about recalling of witnesses, the purpose of cross-examination, etc. And in my view, the step-by-step guide is easy to follow even for unrepresented litigants. To conclude, I may simply say the transition from the lawyer-driven litigation to judicial case management has lubricated the wheels of civil justice system and leveled the playing field for all litigants, represented and unrepresented alike. While recognizing that no system of rules is perfect, many Basotho have benefited from the simplified procedures in this court and satisfactorily presented their claims and defense before the court unassisted. With that, this concludes my presentation. Thank you, Chairperson.
I would like to thank Lady Justice Banyane for keeping within time, but giving us as much as she could within very limited time. I could see that she has some written paper, which I'm sure she'll share with us. Now, let me invite Lady Justice Charlotte Wezi Malonda to give us an overview of the Commercial Division of Malawi. You're most welcome. You can use that. Please, feel comfortable.
Thank you very much, Honorable Chief Justice, for the introduction. I would also like to extend my appreciation to the organizers for ensuring that this panel is gender balanced. I'm here to share about our experiences in the commercial courts in Malawi. So in terms of the specialization of courts in Malawi, they are a creature of statutes. The Courts Act actually categorized and came up with 5 special courts. And before I go into the details of the different courts, I wanted to emphasize that all civil courts in Malawi use the same civil procedure rules. So there is no difference in terms of the procedure The difference is just going to be in terms of the court fees that are payable. So the 5 specialized courts that we have in the Courts Act is the Civil Division. And this Civil Division is there to hear any civil matter which cannot be heard in any other court. So this is where you go after you've realized that all the other courts have rejected your application. They're saying we don't have jurisdiction. You just go to the General Division. And then we have the Commercial Court, which has the responsibility of hearing any commercial matter. The definition of commercial matters is also given in the law. Then we have the Criminal Division, which is there to hear criminal matters. Then we have the Family and Probate Division, which shall hear any family and probate matter. Then we have the Revenue Division, which shall hear any revenue matter. So the Commercial Division has got the jurisdiction to hear commercial matters. And because this is a new creature in our law, some judicial pronouncements have had to be made to provide clarification on what a commercial matter is. Suffice it to say that the law has listed down examples of what is a commercial matter, but some judicial pronouncements have had to be made by us as courts to say, even though it's not given as an example in the law, but this is a commercial matter or this is not a commercial matter. But I wanted to emphasize that the commercial court is a court for serious litigants. This is the court where you go to, where if you walk in, you can smell the money. The environment actually tells you that this is the court that is dealing with serious issues related to money. And the reason why the commercial matter is structured like this is we want the business environment, the business community to have confidence in our decisions. They shouldn't just think that just because they've walked into a court in Africa, this is just a kangaroo court. We want them to know that we are a court that will handle your billion-dollar case seriously, and you should have confidence, whether you win or you lose the matter, you should have confidence that this is a serious court. So in terms of our case laws, we've also tried to give decisions specifying that jurisdiction cannot be assumed. It is conferred by statute, because sometimes you find that litigants have a habit of filing the same case in different courts and just trying to see where the case is going to move faster. So we have tried to streamline and to come up with judicial pronouncements that stipulate that if you are a family and probate division court and you receive a commercial matter, you cannot assume jurisdiction over it, despite what the Constitution says, because now we have specialized courts. So for a case to qualify as a commercial matter, the matter must be a civil matter, and as well, the matter must of necessity have commercial significance, and it also must arise out of or be connected with any relationship of a business or commercial nature. So commercial significance alone is not enough for a matter to qualify as a commercial matter, but it should be a combination of commercial significance and a business relationship that will turn a civil matter into a commercial matter. I was actually also, I related a lot yesterday when one of the keynote speakers also said that you are finding that there are transactions which are actually criminal in nature, but they are coming to courts as if maybe they are civil matters. So for example, you find that a litigant is coming to court, and the story that they're explaining, you find that it's a layered transaction which has been masked as a commercial matter, but actually it's fraud. It's a case of fraud. Maybe you see that this is usury, but it's coming to the commercial court, and the person is saying that I had a contract with this man, I bought his house, I gave him money, but now I need possession of the house. But when you hear the other side of the story, you actually hear that this is actually not a commercial matter, but this is something else. So it is important that as judicial officers, we should always be alive to some of these transactions, which are layered as commercial matters, but they are not. So the courts have on several occasions also expanded on the definition of a commercial matter, and this has helped us to cascade and streamline disposal of cases based on subject matter. So commencement of cases in the specialized divisions is supposed to be encouraged, much as the creation of the different divisions of the High Court does not necessarily impeach Section 108 of the Constitution, which gives the High Court original and unlimited jurisdiction. So now I'm just going to share some of the observations that have also been made. It has been observed that specialized courts have improved efficiency and service delivery. For example, each special court has structures that are suitable for the subject matters that will be handled for that court. For instance, commercial courts, the structures set up in a way that raises the confidence of the business community that Malawi is open for business. The environment, the ambience, the dressing of the court officials, the courtroom, the judges' chambers, all done in a way that should give confidence to the litigants that I've come to the right place for my commercial case to be handled. We don't have rooms to keep accused persons at the commercial court. We don't have child-friendly structures at the commercial court because those are not our normal court users. So it is actually a grave injustice if a case is filed in the wrong court for purposes of forum shopping or for other undesirable purposes. So experience has shown that commercial courts as well charge special fees, which are at times higher than the court fees in other courts. And this is also because of the peculiar services that the commercial courts are supposed to provide. So you find that the filing fees is higher and other processes tend to be more technical than in other courts. So commercial courts also work efficiently when the court users are more conversant on how to go through the court processes. We've experienced cases where a litigant is unrepresented, and much as you try to assist them to go through the processes, but the more advanced the case goes as you are preparing for trial, you start seeing that the litigant will have problems in preparing their documents because they will need some level of knowledge in terms of commercial law. So preparation of the pleadings, the skeletal arguments, they have to be streamlined with commercial law. So it is normally encouraged that litigant is represented, though it's not compulsory. A substantial number of commercial cases have also been disposed through mediation, and we don't have a lot of full trials. And this is attributed to the fact that businesses face justice and predictability of outcome as opposed to the uncertainty of having a full trial. Legal aid is rarely provided for commercial cases. Hence, litigants have to show the high legal cost because the nature of commercial cases requires a lawyer who is conversant in commercial law. And most lawyers who have an appreciable commercial law experience are quite expensive. According to the law, if the case is filed in the wrong court, the one who commenced the case in the wrong court is supposed to pay the cost of transferring this case. And to conclude, I'd like to highlight that specialized courts require active case management. And this active case management is supposed to be propagated by the court itself, the assistant registrar, and the lawyers. Because proceeding to handle a case which has been filed in the wrong court is fatal for the parties and can occasion unjust outcomes, because you'll find at the end of the day that the reliefs which the litigant wants cannot be provided in this particular court. So the litigant and the lawyer have a responsibility to draft their pleadings seeking specific reliefs from the right court. I would like to repeat the statement of our Deputy Chief Justice, Justice Chikopa, who said in a case that it is not the responsibility of the court to give free legal advice. So the court is not going to start telling you that go to this other court, but you as a lawyer, you are supposed to know which is the right court for your case. On the other hand as well, the registrar who has the responsibility of issuing the court documents should also be alive to read the facts, understand them, and know that if the facts of a case do not lie in the commercial court, then they should not issue the court document because the remedies cannot be provided in this actual court. The lawyers as well, when they prepare the pleadings, they should also desist from forum shopping. They need to commence their proceedings in an appropriate court based on the remedies that they want. And as an adjudicator, as a judge, you should also actively manage the case and make a determination on the issue of jurisdiction at the earliest opportune time. Because the more you advance in terms of the proceedings, you are going to cause unnecessary delays and high cost for the parties when the issue of jurisdiction has not been determined. So currently the commercial court in Malawi has 7 judges and it is operating in 3 registries, which are in different regions of the country. And our case disposal rate is also very high. So I think I still have some time and I will share my time with my brother judge.
Thank you very much for lending some of the precious time to others and also for discussion. Justice Malonda, thank you very much. Now it's time to hear from Mr. Justice Esmeraldo Matavele. He's going to discuss juvenile court in Mozambique, its organization and functioning. You're most welcome.
Thank you, Honorable Chief Justice. Good morning, Excellencies. All protocol observed. First of all, I want to say that as it happened yesterday with my boss, Honorable Dr. Pedro Nyatitima, me as a Mozambican, I do not speak English very well, but I will try to say something in English because even you, when you go to Mozambique, you try to speak Portuguese. So me too, I have to try to speak English. I'm going to talk about the juvenile court organization and functioning. I don't know if everything is okay. Okay. Under the Constitution of the Republic of Mozambique, the national legal order has 3 main types of courts. We have the Supreme Court, the Administrative Court, and the Judicial Courts. The Juvenile Court was created in 1993 as a court of specialized jurisdiction for matters involving minors, that is, individuals under the age 21. The Juvenile Court is specially responsible for judging the following cases: alimony, child custody, guardianship of minors, adoption, and criminal prevention, among others. The process most received are those related to child custody. In this process, normally the child's parents are divorced, and the part that stays with the child wants to maintain custody, but also asks the other part to contribute maintenance in favor of the minor. When receiving this type of case, as well as most of other cases, the judge schedules a conference to try to reach conciliation between the parties. When the judge cannot reach an agreement between the parties, he closes the conference and sets a date for the trial where each part will present evidence to support their position. Before making a decision, the judge requests the opinion of the juvenile curator, who is the prosecutor assigned to the section. The juvenile curatorship works next to the court, and it is the entity that receives the citizen and makes the requests, submitting it to the judge. According to the law on guardianship organization of minors in Mozambique, this area is voluntary jurisdiction guided by the best interest of the minor. Sometimes the parties bring their own problems, especially the reason for divorce, to the discussion. However, judges try to rule out these aspects, prioritizing what is really important for the minor. For the effective exercise of its function, the juvenile court requests collaboration from other public or private institutions. For example, to establish the value of the alimony, the court requests income statements from the institutions where the defendant works. Failure to present response to requests or the provision of false information gives rise to criminal liability, which the judge being responsible for extracting copies for the criminal code. Generally, the process ends with a sentence, which, unlike what happens in other areas, as it is a voluntary jurisdiction, can be changed at any time if circumstances so require. On the other hand, if the parties intend to appeal the sentence, the effect is, as a general rule, merely devolutionary, which means that the decision taken in the first instance must be complied with despite the challenge to a higher court. At the moment, in Mozambique, there is only one juvenile court, the juvenile court of the city of Maputo, where I work. The court operates in 7 sections, headed by judges appointed by the deliberation of the Superior Council of the Judiciary. The 7 sections are also made up of judicial officers, including the law clerk, diligence officers, and the social action assistants. In the remaining 10 provinces, as well as in around 160 districts, jurisdiction over minors is exercised by the civil, family, or minors is exercised by the, in the remaining 10 provinces, as well as in around 160 districts, jurisdiction over minors is exercised by the civil, family, or minor section, as well as the common judge. The functioning of the sections of courts observes the aforementioned rules and the principles related to juvenile courts. Challenges: transformation of the juvenile court in the country's capital into a family and juvenile court, allowing the judge to access other aspects related to the family, such as divorce, legal separation, investigation, or challenge of paternity. Number 2, need to allocate specialists from other areas of knowledge, such as psychologists, to assist the judge in making his decision. Shortage of human and material resources for the best functioning of the court. So I will end here and thank you very much. Muito obrigado.
Thank you so much, Justice Matavele. And also thank you for saving some time, which will be utilized for discussions. Now, I would like to invite Mr. Justice Evaristo Pengele. He's going to discuss Economic and Financial Crimes Division of Zambia. Mr. Pengele, Mr. Justice Pengele, you're most welcome.
Thank you very much, Chairperson. My Lord, the Chief Justice of the Republic of Uganda, my Lord, the Chief Justice of the Kingdom of Eswatini, allow me to ride on the protocols already established. I must say, as already introduced by the Chairperson, that I was the coordinator of the forum until 2021. I was coordinator for 5 years. It feels good to come back as a representative of the Chief Justice. It feels good in a different, because I didn't have to run up and down like I used to. So our Economic and Financial Crimes Court is a very new court. It was established in 2022. So in his speech at the ceremonial opening of the criminal sessions of the High Court on 7th January 2022, the Honorable Chief Justice of Zambia, Dr. Mumbamalira State Council, announced the establishment of the court. So then the announcement was followed by the enactment of the Economic and Financial Crimes Division of Court Order 2022. The establishment of the court followed public calls for speedy disposal of corruption and economic and financial crimes. And in his speech announcing the establishment of the court, the Honorable Chief Justice agreed with the public cause when he said, and I quote, that crimes of economic nature especially deserve expeditious disposal because of their effect on the economy of the country, end of quote. Before the introduction of the Economic and Financial Crimes Court, corruption and economic and financial crimes used to take inordinately long to be disposed of by the courts, both at trial court level as well as appellate court levels. For example, a subordinate court acquitted the former president of the Republic of Zambia, Dr. Frederick Chiluba, of corruption charges after a trial of 6 years. At the appellate court levels, the classic example is the case of Stella Chivandamumba, Katere Kalumba, Faustin Kawe, and Aaron Chungu versus the people. Among the accused persons in that case were a former Minister of Finance and a former Permanent Secretary in the Ministry of Finance. The accused persons in that case were arrested and charged of corruption and abuse of authority of office involving 20 million United States dollars in 2004. They were only convicted by the subordinate court after 6 years in 2010 and sentenced to 5 years imprisonment. The convictions were later upheld by the High Court in 2013. The convicts lodged a further appeal to the Supreme Court, and the Supreme Court only confirmed the convictions in 2022. So since all the convicts were on bail pending appeal from the time they were originally convicted by the subordinate court, they only started serving their 5-year jail sentences nearly 20 years from the time they were brought into the court system. So as a result of these delays and many other factors, the Honorable Chief Justice got inspired to establish the court. So I'll look at the establishment of the court. At the High Court level, the court has been established as one of the divisions of the High Court, pursuant to the Economic and Financial Crimes Division of Court Order of 2022. Then there is also a division in the subordinate court, which has been established pursuant to Section 3A of the Subordinate Courts Amendment Act number 23 of 2023. When the court was originally established, it did not have specialized rules for fast-tracking cases. The court relied on the rules which are applicable to the general criminal matters. For this reason, the pace at which cases were heard and determined still remained slow. On 26 January 2024, the Honorable Chief Justice made the Economic and Financial Crimes Court Rules of 2024. The rules came into operation on 1st March 2024. They, however, also applied to the conduct of proceedings for cases commenced before 1st March 2024. So I'll briefly highlight the salient provisions of the Economic and Financial Crimes Court Rules. First, starting with the procedure before the court, it must be noted that in addition to the Economic and Financial Crimes Court Rules, the procedure before the court continues to be predominantly governed by the Criminal Procedure Code. I'll look at the duration of proceedings. The most notable feature of the court is the introduction of a time frame of 5 months within which the court should hear and determine a matter before it. The 5 months period starts running from the date on which plea is taken or an appeal is filed, as the case may be. The rules recognize the fact that there may be instances where, for some reason, the court may not conclude the case within the 5 months allocated. To this extent, the rules empower the court, on an application by a party or at the court's instance, to extend the period for conclusion of a matter for a period not exceeding 45 days. If the court fails to dispose of a matter within the period specified by the rules, the court is required to render a report, in the case of a judge, to the judge in charge, and in the case of a magistrate, to the chief registrar, explaining the reasons for the delay in disposing of the matter. Further, where the delayed matter is pending hearing, the court is required to state the directions that it has given to the parties for the hearing of the matter. And where the matter is pending delivery of judgment, the court must state the new date given to the parties on which judgment shall be delivered. In order to further minimize delays, the rules enjoin the court not to grant an application for an adjournment except in compelling and exceptional circumstances. In addition, the rules do not allow parties to appeal against a decision of the court arising from an interlocutory application. Dissatisfaction with such a decision can only be raised in an appeal against the final judgment of the court. The proceedings of the court. In order to make it more feasible for the court to hear and determine matters within the 5 months, the rules require that at the time of filing the charge, the prosecution must also file A, a list of witnesses to be called at the trial, B, witness statements for those witnesses, and C, a list and copies of documents to be relied on at trial. The prosecution will not be allowed to rely on a document or a witness statement which has not been served on the accused person. In addition, the prosecution will not be allowed to call as a witness a person who has not been named on the list of witnesses. However, the court may permit the prosecution to file a document or witness statement if the court is satisfied that the document or witness statement was not available at the time it was required to be filed. Pre-trial conference. So in order to make the proceedings more court-driven and to allow the court to properly manage the tight timeframes, the rules have introduced a pre-trial conference and a pre-defense conference. There are numerous case management and compliance issues that the court considers at the pre-trial conference. The court will additionally proceed to issue the date for taking of plea. Further, in consultation with the parties, the court will issue a timetable for the progress of the matter. In addition, where parties request, the court may allow the parties to plea bargain within a specified period of time. At the conclusion of the pre-trial conference, the court must issue directions which should include A, the date of commencement of trial, and B, the length of the prosecution's case. Disclosure by the defense. Where an accused person is found with a case to answer, and the accused intends to lead evidence in defense, the accused must file any document intended to be relied upon in defense within a period of 14 days from the date of being found with a case to answer. The accused will not be allowed to rely on a document which has not been disclosed. I think you will note that for the accused person, there's no requirement to file witness statements. The rules, however, give discretion to the court to allow an accused person to rely on a document that has not been disclosed if A, the document was not available at the time of the disclosure, and B, it is in the interest of justice to allow the disclosure of the document. So you will see that for the prosecution, this aspect of the interest of justice to disclose a document is not provided. It's only provided in respect of the accused person. Pre-defense conference. The court will then summon the parties to a pre-defense conference. Among the issues that the court will address at the pre-defense conference are the number of witnesses that the accused person intends to call and the approximate amount of time that the accused's case shall take. At the conclusion of the pre-defense conference, the court will set a date for commencement of defense. I'll look at the general provisions briefly. In order to allow for some level of flexibility, the rules give discretion to the court on an application by a party or in certain circumstances at the court's instance to abridge or extend the timeframes specified in the rules for taking any step in connection with the proceedings. I'll look briefly at the challenges. There are a few teething problems. The main challenge really is a question of adjustment by adjudicators, prosecutors, defense lawyers, as well as accused persons to the fast-track nature of the court. Furthermore, the rules call for a lot of hard work and commitment in light of the requirements for cases to be concluded within a period of 5 months. In addition, some defense lawyers have complained that some magistrates allow many adjournments during the case for the prosecution. Then when the 5 months period is about to expire, such magistrates put the accused person under pressure to quickly conclude the defense case. The Chief Justice has taken note of the above and other teething problems. To this extent, a number of training workshops are being held for adjudicators and prosecutors. I'll brief some of the successes. Since the rules have only been in force from 1st March 2024, their full impact on the rate of disposal of cases is yet to be properly assessed. However, preliminary indications by adjudicators are that the rules have made proceedings more court-driven and thereby enhanced efficiency. Another success brought about by the establishment of the court is that apart from sending those found guilty to prison, a lot of properties, including money, have been recovered through non-conviction-based forfeitures or civil forfeiture proceedings under the Forfeiture of Proceeds of Crime, number 19 of 2010. Examples are many. I'll only look at 3. One of them is the case of the people versus Charles Loyana and Susan Sinkala. This was an interesting case in that the 2 convicts were husband and wife. Charles Loyana was a senior accountant in the Ministry of Finance, while his wife, Susan Sinkala, was an assistant accountant at the Ministry of Works and Supply. On 30th June 2023, they were found guilty of corrupt practices involving the possession and concealment of 48 houses valued at 37 million kwacha, which is equivalent to 1.4 million United States dollars. They were sentenced to 3 years imprisonment, and the 48 houses have been forfeited to the state. Another example is the case involving the former Deputy Inspector General of Police, Charity Katanga. The court convicted Madam Charity Katanga in February 2024 for inter alia the offense of possession of tainted property involving 10 Higer buses valued at approximately 1 million United States dollars. She was sentenced to 3 years imprisonment, and the court ordered the forfeiture of the 10 buses to the state. And more recently, on Friday last week, 27th September 2024, the court made a non-conviction-based forfeiture order for 15 double-story flats belonging to Mrs. Esther Lungu, the wife of the immediate past president of Zambia, Mr. Edgar Lungu. The flats were valued at 66 million kwacha, which is approximately 2.5 million United States dollars. In conclusion, one would submit that the Economic and Financial Crimes Courts are an important judicial platform for the expeditious disposal of corruption and other economic and financial crimes. Although the Economic and Financial Crimes Court of Zambia started at a relatively slow pace, early indications show that the enactment of specialized rules to fast track the cases will have a positive impact on the rate of disposal of cases. I thank you.
Thank you. Thank you so much, Mr. Justice Pengele. And I would like now to invite Mr. Justice Maxwell Gicheru, Environment and Land Court of Kenya, to give his remarks.
Thank you. Thank you, Chief Justice, for this chance. My presentation will be shared on the screen, and it has 17 slides. And the first one is about the outline. So I'll talk about the hierarchy of courts in Kenya, the origin of thank you. The origin of the Environment and Land Court, the jurisdiction of the court, achievements in the last 12 years, challenges, and then a conclusion. So on that page, you can see the hierarchy of courts, the Supreme Court at the top, the Court of Appeal, then we have the High Court, and the Employment and Labor Relations Court, and the Environment and Land Court at the same level. Then we have the subordinate courts, which include the tribunals, magistrates' courts, and other courts. So the origin of the ELC, that is the acronym that we use in Kenya for the court. Before the promulgation of the 2010 Constitution of Kenya, we did not have the ELC court. So it's a creature of the Constitution and also the Environment and Land Court Act. So you can see the reason. So we start now with the reasons why the court was created. And Kenya has had a multiplicity of land laws and a complicated history of land disputes. And land disputes constitute a huge percentage of suits filed in Kenyan courts. So there was growing litigation in the land and environment arena. There was need to tackle backlog of land cases. And Kenya relies so much on agriculture. And because agriculture contributes to 33% of Kenya's GDP. So land needs to be released to development and investment and not to be tied up in litigation. So it was appreciated by the people of Kenya that environment and land matters are technical in nature and required to be heard and determined by judges with special expertise in the area. So there were two commissions that were formed to look at the land problems in Kenya. So first of all, we had the Jonjo Land Commission of Inquiry into the land law system, and it proposed constitutional and legislative principles and framework for governing land in Kenya. And the commission was, the Jonjo Commission was followed closely by the Ndongo Commission, which was inquiring into irregular and illegal allocation of public land in Kenya. And it recommended that a land titles tribunal be set up to handle the many cases that were brought to the general courts in Kenya. So the judiciary, in reaction to those two reports, set up two divisions of the High Court, one in Mombasa and the other one in Nairobi. And that was in the year 2007. This did not help because the judges handling these matters were not experts. And we had so many cases filed across the country, while the divisions were only in Mombasa and Nairobi. So it became clear that there was a need for a separate court for land and environment that had the same status as the High Court. So the committee of experts, which was working on Kenya's constitution in the year 2010, recommended that a specialized court for land and environment be set up. So that is how we came to have the ELC. So the jurisdiction of the ELC, as we said earlier, comes from the Constitution, Article 169(2)(b), which says that Parliament shall establish courts with the status of the High Court to hear and determine disputes relating to 1, environment, 2, use, 3, occupation, 4, title to land. The jurisdiction of that court is that narrow. And the second source of the jurisdiction now is the Environment and Land Court Act, which elaborates on the jurisdiction to include the following areas of disputes. So there we are: environmental planning and protection, climate issues, land use, planning, title, tenure, boundaries, rates, rents, valuation, mining, minerals, and other natural resources. Then we have compulsory acquisition of land, land administration and management, public land and public, private, and community land contracts, choices in action, and other instruments granting any enforceable interest in land. Then any other dispute relating to environment and land. Then the second tier is petitions for redress of, denial, violation, infringement, threat to rights or fundamental freedoms relating to a clean and healthy environment. Then the court has appellate jurisdiction over the decisions of the subordinate courts or local tribunals in respect to matters falling within its jurisdiction. So the court has power to grant those reliefs. You can see mostly they are the common law reliefs that the High Court would grant: interim or permanent preservation orders, including injunctions, prerogative orders, awards of damages, compensation, specific performance, restitution, declarations, costs. So the structure of the court is, as you can see, we have a presiding judge who is elected by the ELC judges every 5 years, and he supervises the ELC courts across the country and reports to the Honorable the Chief Justice. The PJ is assisted by a registrar, legal researchers, deputy registrars, and judicial staff to facilitate the court to discharge its mandate. Currently, there are 52 of us serving in 37 stations across the country. Kenya has 47 counties. So most of the counties are covered by the ELC court. Then in July 2023, the court was subdivided into 2 divisions: Environment and Planning Division, the Land Division. And this initiative was begun in Nairobi Station, and it's expected that the rest of the stations will follow suit, depending on the number of cases filed. But what happens now is that where there are no divisions, the judge at the station where there are no divisions deals with both environment and land matters. So the achievements in the last 12 years, so the court is the principal avenue for peaceful resolution of conflicts over the environment, natural resources, and land. It is the driver of green jurisprudence in Kenya. It has developed. It has developed jurisprudence that is responsive to Kenya's social context of high prevalence of conflicts over land. It has reduced backlog from 27,000 cases in 2016 to about 14,000 in 2021. And when the courts are ranked in terms of performance, the ELC is always ranked in the annual performance management evaluation as a high-performing court. So the presence of the court in 37 out of Kenya's 47 counties has greatly enhanced access to justice for the disadvantaged and marginalized. It has created great public awareness of environmental issues in the country. It has enhanced the image of the Kenyan judiciary, regionally and internationally, and its decisions have been cited globally by other judiciaries and tribunals. In the year 2022, the court hosted its inaugural conference to celebrate 10 years of its existence. Stakeholders in land, planning, environment policy, and justice chain met in Malindi, and they deliberated on the achievements and challenges and how the court can improve and strengthen its services. In our ELC court, and I think in other courts as well, 90% of the court business is conducted virtually. And this has assisted in reducing costs and time to the parties and the advocates. And it's one of the greatest achievements, I would say. Then we come to the challenges. We have ICT challenges for litigants who cannot read and write. Recording of evidence in longhand causes delay. Adjournments by litigants and advocates who are not keen on finalization of their matters. Non-execution of court orders by government agencies at the national level, as well as the devolved level. Then we have jurisdictional overlaps with the constitutional and commercial divisions of the High Court, which lead to forum shopping, delays, and duplication of disputes. So there is the issue of justiciability of the environment issues owing to few cases filed in that department, so that most of the cases that we deal with are actually land and few from environment. Then we have inadequate budgetary allocations. Then we have low uptake of AJ across the entire country, and more so in Nairobi, where demolitions have been ordered by the court. Last year, we had demolitions ordered in Jiro, in Nairobi, where people settled grabbers and trespassers occupied land for many years belonging to a private individual. And when the court ordered demolitions, that's the time they went to negotiate with the owner of the land. In Mavoko, many people had built land built houses and other infrastructure on public land, and the court ordered demolitions. And it was a very serious issue, and there was a hue and cry, but the court orders were executed in that case. Then we have had cases in Kitengela, where a church built on public land was ordered demolished. So land grabbers in Kenya are worried a lot because of the impact the ELC has made in Kenya. Thank you very much.
Now I would like to invite Honorable Lady Justice Susan Okalany to discuss gains of the International Crimes Division, Uganda. Most welcome.
Thank you, my lord. My lords, distinguished delegates, good morning. I would wish to first thank His Lordship, the Chief Justice of the Republic of Uganda, for choosing the ICD to, among the several specialized divisions of the High Court, to share its gains. I will look at the background of the court before I discuss or explain the gains. The Lord's Resistance Army, the LRA conflict, was long and very brutal. It spanned over 29 years, claiming millions of lives. It was founded by Joseph Kony, whom the ICC recently attempted to try in absentia. The conflict covered most of the northern Uganda and parts of the northeast Uganda. And later it spread to other countries, South Sudan, the Congo, and the Central African Republic, where actually Joseph Kony is believed to still be operating from. Between 30,000 to 66,000 people were abducted by the LRA. There were mass killings and displacements. Many people from the northern region were placed in internally displaced people's camps. Human rights violations were committed by the LRA. And currently, it is believed that LRA consists of splinter groups with about 1,000 members, and they are residing in the Central African Republic. In 2006, the LRA and the government of Uganda entered peace negotiations in Juba. These were aimed at ending the conflict amicably. However, the government of Uganda had already sought assistance from the International Criminal Court, and arrest warrants had been issued against the LRA commanders. The peace agreement that was signed was called the Agreement on Accountability and Reconciliation. That one was signed in 2007. However, negotiations continued between the government of Uganda and the LRA. Disagreements ensued over the UPDF, Uganda People's Defense Forces, accountability and withdrawal of the ICC warrants if the peace agreement was to continue. This led to the collapse of the agreement or the negotiations. However, the government of Uganda went ahead with implementation of some of the terms that had been agreed on in the Agreement on Accountability and Reconciliation of 2007, and established the War Crimes Court, which was later renamed the International Crimes Division of the High Court by an instrument that was issued by the Chief Justice. Four judges were appointed and support staff were trained. Subsequently, other judges were posted to the division, including the Chief Justice. He was still a trial judge at the High Court. When the division was established, the DPP followed suit and established a department of the international crimes and transnational crimes. The police followed suit and established several units, including a specialized department to investigate sexual violence in conflict and cases of international criminal law and transnational crimes. In 2011, Thomas Coelho Latoni, a former Lord's Resistance Army colonel, was produced before the International Crimes Division for trial. The trial was complex as his legal team raised questions about the armed conflicts classification under the Geneva Conventions and also the constitutionality of the Amnesty Act. The matter was referred by the then trial judge to the Constitutional Court, which halted the trial in the High Court and delivered a ruling that said that Thomas Coelho was entitled to amnesty, like the other commanders and combatants. The Attorney General appealed the decision of the Constitutional Court to the Supreme Court, which later overturned the decision of the Constitutional Court. Uganda has a history of amnesty. The Amnesty Act was passed in 2000, providing amnesty to all those who renounced rebellion, and the act had already, by the time of Thomas Coelho's trial, benefited about 27,000 combatants and 28 armed groups. Half of these groups or combatants were from the Lord's Resistance Army. So basically, the trial of Coelho highlights the complexities of transnational justice in Uganda and how to balance that with accountability and also reconciliation. The trial resumed in 2017 with pre-trial proceedings that I presided over because the ICD had now made rules of procedure similar to the ICC rules of evidence and procedure. I confirmed over 93 charges against Thomas Coelho, falling within the rubric of war crimes and crimes against humanity, as well as penal code crimes. Eventually, the trial commenced. The main primary trial, presided over by 3 judges with 1 judge in waiting. That was in 2020. Multiple witnesses testified, and Thomas Coelho was put on his defense just this year. Subsequently, the court facilitated the defense of Thomas Coelho, including paying for his lawyers. And he was able to provide his defense, and he was recently convicted of about 60 charges in the indictment and acquitted of 3, I believe it's 3. The other charges were dismissed because they were alternative counts. Apart from Thomas Coelho's trial, because of the presence of terrorist groups such as the ADF, ISIS affiliate, Al-Shabaab, Islamic State Central Africa Province, ISCAP, in the neighboring DRC, the ICD has conducted several trials of terrorist suspects, including the Kampala 2010 bombings, which was presided over by the Honorable, the Chief Justice, when he was still trial judge at the ICD. We have also conducted several human trafficking trials. I will now enumerate the gains of the ICD. I know that you are going to go to Google and discover in your research the struggles of the ICD. At a certain point, it was not even believed by academia, civil society organizations, and the media that the ICD would actually successfully hear and determine war crimes and crimes against humanity. Now, in all the challenges that we faced, the good things that resulted are, firstly, development of jurisprudence. In interpreting the Amnesty Act and its application to serious crimes or international crimes, the ICD, of course, through the Supreme Court's decision, has shown that there has to be a balance between amnesty and justice, underscoring the pressing need for directives on using amnesty cases involving grave international crimes. The case also led to the interpretation of the principle of legality under our Constitution and the application of customary international law as a basis for preferring charges. This was so because some of the offenses that were preferred by the DPP were brought under customary international law, there having been a lacuna in the law that necessitated such charges to be brought. And of course, the defense objected to this, saying it had never happened in the history of our country that charges not framed in or specified in criminal laws can be preferred. The other gain is applying a victim-centered approach. The ICD rules allow for victim participation. However, the rules were not very clear and categorical about how exactly victims can participate. This was another area of contention during the pre-trial, and the ICD ruled and affirmed its commitment to a victim-centered approach, ensuring that victims' voices and needs were very central throughout the trial. The court allowed victims to be represented as participants, not as parties, in line with the practice of the International Criminal Court. Also, as a gain, by hearing this case as an international case, international crimes case, the ICD has demonstrated justice and accountability, that domestic courts can try cases, international crimes cases, in their own right without having the accused persons produced to the ICC. Capacity building. The ICC has facilitated the training of judges, prosecutors, defense lawyers, and other staff, improving their capacity to handle complex international and transnational crimes. It has also, through orders issued by the court, improved the investigation skills of the police and strengthened the prosecution as well. through the orders that the court has rendered in the course of trials, not just of Thomas Coelho's case, but there's so many terrorism cases that we try. The other gain is, of course, deterrence and prevention. I will not belabor that because it can be argued that the delay in completing some of the cases like Thomas Coelho and others that are still pending will not bring deterrence. Engagement with the media. The ICD has been very proactive and transparent in reporting and countering misinformation on its work. Early planning and case management. Because of the need for proper case processes, the ICD has adopted a structured case management protocol to enhance efficiency and effectiveness. This is so especially because of the numbers. There are just 4 judges in the ICD, and yet some of our cases, because of their nature, the complexity of the cases, including terrorist cases where there are over 100 charges or indictments, there is a need for planning, proper case planning and management amongst the judges to leverage on the resources that we have. Of course, we have tried to manage, the resources that we have, including the expert knowledge. It should be known today that the judges that have been trying the Thomas Coelho case are not judges of the ICD. These are judges that we have borrowed from other divisions because of their expertise. Some of them worked for UN tribunals as legal counsel or prosecutors. Others were professors or teachers at the Law Development Center teaching criminal law. And so they had expertise on the subject. Of course, the ICD has demonstrated complementarity, the positive complementarity as it is known, by trying Thomas Coelho successfully. And recently, the ICC prosecutor opined following an objection by defense lawyers in the Joseph Kony trial. He agreed actually that Uganda now has the capacity to handle the war crimes that were originally referred to the ICC. Challenges. Despite these gains, some challenges persist. Funding and logistical constraints. I think that is a common problem always. Arising especially from the misunderstanding of the work of the ICD, where many of our own colleagues were saying, why should a case take $100,000 when a whole trial session, criminal session of 50 cases takes less than a quarter of that money? Re-emphasizing the fact that he who kills one can easily get tried and convicted than he who kills 1,000. Of course, there's a challenge of dedicated judges. We have built capacity now, but we are still few. And the answers or recommendations to these challenges are almost obvious. Increased funding, and we support the Secretary of the Judiciary for appreciating the complexities of the cases handled at the ICD. Dedicated judges, we need to empower more judges to handle international and transnational crimes. Capacity building, we need to continue to do that. By addressing the challenges and building on its gains, the ICD has the potential to serve as a beacon of hope for specialized courts in Southern and Eastern Africa, enhancing justice and accountability. Thank you.
Thank you so much, Lady Justice Susan Okalany, for a very, very insightful presentation. Now, ladies and gentlemen, I think we have had some very, very good presentations, and they have given us sufficient matters for us to discuss. And we have 30 minutes for discussion. And essentially, this plenary session is for sharing of our own experiences from our various jurisdictions. And I'm sure there is a lot which we can share, especially the speakers have tried to show the big pictures, the big results, which have come out of the initiatives of establishment of specialized courts. And I'm sure in our jurisdictions, we have challenges, and we have a lot to share. So we have less than 30 minutes. If you can raise your hand, identify yourself with your jurisdiction, where you come from, and utilize as few minutes as possible, so as most of us should have time. Honorable Chief Justice of the Republic of Kenya.
Thank you very much, Chair, and the eminent panel for your presentation this morning on the efficiency brought in your jurisdictions by embracing specialized courts. I have two questions and then maybe a comment. I would like to know the case clearance rates in your courts, because you know we have a huge problem, at least in my jurisdiction, on the number of years or the time the case takes in courts. Now that you have specialized divisions, what is the case clearance rate? I'm very impressed by Zambia, the creation of the Specialized Economic Crimes Division and the no adjournment policy. My question would be on barring interlocutory applications, whether you have found any headwinds on that, because we're trying to do that in Kenya, especially for the trial of election petitions, which has a time frame of 6 months, but you find parties challenging the constitutionality of stopping them from accessing justice by barring interlocutory applications. The comment I want to share is that the specialized way actually brings efficiency to access to justice. The problem we have is in resources, having enough judges who can specialize, especially in the regions, apart from the big cities. But we've tried to do it, commenting also on the Mozambique that has established the children's court. The way we've done it, because we know children are not only located in the big cities where we have children's courts like Nairobi, Mombasa, Nakuru, we set a special day when the children matters can be heard. And on that day, there is no other case, so that the children will not be mixed with other parties. We've gone ahead also and established registries for gender-based violence. We piloted with a court, which was named the SGBV, Sexual Gender-Based Violence. And from the lessons learned from that court, we were guided that the best way is to establish registries in areas that have many cases of SGBV. And then the cases are given priority because they are coded differently. You know, the victims, mostly they are women and children, especially children, and they are given priority and allocated to the magistrates, distributed evenly, because we realize giving one judicial officer cases of that nature was really wearing them down, and they were suffering from burnout because of the trauma from the victims. So that is what we would like to share, that even if you don't have a full-fledged court, there is a way you can expedite cases, especially where the victims are very vulnerable. Thank you very much.
In the hand which I can see my Lord Chief Justice Malawi.
Thank you, my Lord Chief Justice, the Chair. And I would like to join the Lady Chief Justice in thanking the presenters for highlighting the benefits of divisions, creating divisions in the courts. And listening to all of them, you can see the efforts that are being made to ensure that we can improve access to justice through creating divisions. And then talking about the challenges, they seem to be very common challenges. One of the items that has come out clearly to me is about the challenge of jurisdictional overlap. I wonder whether we have experience on the floor on how we have dealt with this issue of jurisdictional overlap, even amongst the various divisions. Sometimes people have said, you have a criminal division, quite all right. Why create a financial and economic crimes division when you have a criminal division? So these issues about jurisdictional overlap tend to cause a lot of difficulties in our own settings. Any experiences on the floor as to how this has been dealt with? Thank you.
Thank you. Honorable Chief Justice Namibia.
Thank you. Thank you, Mr. Chairman. I also wish to commend these presenters for the very insightful presentations that they have made. I was particularly intrigued and at the same time, my thoughts were reawakened, particularly by the presentation made on behalf of the court in Zambia by Mr. Justice Pengele. By the way, Mr. Justice Pengele, congratulations seeing you on the other side. In fact, Mr. Justice Pengele is the third coordinator of the forum who has become a judge of the High Court in Zambia. So it pays off to become a coordinator, it seems to me. But many of the things that you said about the policy considerations that gave rise to the establishment of the court resonate with us in my jurisdiction in Namibia. The experience that we have had in financial and economic crimes is that there has been inordinate delays, particularly coming from the accused persons, which is intrigued because ideally you would have thought that an accused person would want the trial to be finalized as soon as possible. But sadly, that is not the case. What we see is that every conceivable ruling in the case in our jurisdiction is sought to be appealed against. And a lot of debate had gone on whether that ruling was appealable or not. The result is that the trial that should have started a long time ago has not started. The latest application we gather is to have the judge who is presiding over the case recuse himself. And sadly, that application has gone as far as the Supreme Court, resulting in further delays. And remember that these are persons who are in custody, and for some reason, there is a very conceivable delaying tactic, to ensure that the trial does not commence. I wonder what your experience was in Zambia, because as you said, the matter that gave rise to the establishment of the court took about, if I understand it correctly, 20 years before it finally concluded. What were the possible causes of a delay? Are they related to the context of my question that I gave to you?
Now, in this forum, we always encourage It's a forum of chief justices, but we also encourage judges and others also to share. It's the only time you meet the chief justices. Honorable Chief Justice of Zimbabwe, and then there is a hand there. There is a hand there.
Thank you very much, Mr. Chair. Let me congratulate the presenters as well for a very erudite presentations. I just have one question for Justice Pengele. I'm not quite sure whether the differences in the names of these courts is in the form or substance. I want you to be clear on that, because most of the courts that have been adopted in the processes of reforms of the judiciaries have had the same purpose and almost the same substance, but different names. For example, they have been called corruption courts. Now, you are talking about economic and financial crimes divisions. What is the difference? Are they not the same? We in Zimbabwe adopted the corruption courts framework with a broader definition of the jurisdictional content, which would include economic and financial crimes. Is there any difference really in terms of substance?
Honorable Chief Justice of South Sudan, your hand was up.
Yes, my first word is I want to thank the presenters. The presentations they made were very impressive, very educative. And as we listen to these handsome young judges, beautiful judges, ladies, judges, it was very nice. I have learned a lot from this, and I hope we will benefit from it back home. We do not have a lot of these specialized courts in South Sudan. All we have is, we have a gender-based violence court and a juvenile court. We decided to establish these two because some of our tribal customs are not good, and they tend to undermine fundamental human rights. That is why we decided to do that. When these two courts were established, everybody was very much impressed, including our president, General Salva Kiir. So he decided to give to the judiciary a very beautiful building, a two-story building to be belonging to the judiciary. We use it as gender-based violence court and the juveniles. From among the international partners, UNDP and the Kingdom of Netherlands were equally very happy. They came in to do the, what do you call it? It needed some research, maintenance. And the UNDP, in cooperation with the Netherlands Embassy, they built a special hall, courtroom for the women and children as a waiting room. They provided chairs, they provided even small beds for children. Very wonderful. Now, we are thinking, after learning from you people, we will try our best to make sure that we expand this specialized courts to include courts about environmental issues, the climate change, the wildlife protection courts, the labor courts. We would also like to have matrimonial disputes specialized courts and the human trafficking courts. Thank you very much, my brothers. I will stop here, and I would want to have all these presentations so that I can share them back home with my colleagues and our government. Shukran.
Thank you very much. Maybe we have the two last hands so that we do not disrupt the coming session. Please, you have the speaker.
Thank you. I would first of all like to thank the presenters for the presentations.
Can you please introduce yourself? And
we have learned a lot from them. Irene Muliagonja. I'm a judge of the Court of Appeal Constitutional Court in Uganda. My interest in responding was on the commercial court. The presenter from Malawi, she explained to us that it's a court for serious cases of a serious commercial nature, although we did not get the particulars of the seriousness of the cases or the categories of cases. My concern was about the fact that in some of the cases, parties are allowed to come to the court without representation. And my concern comes from the fact that I did sit in the commercial division of the High Court of Uganda, which is a specialized court for commercial cases. The seriousness of commercial cases in this jurisdiction was based on particular categories of cases, complicated commercial cases. Yes, we did call them serious commercial cases. But the fact that you came to the commercial court in this jurisdiction meant that your case also had a high value in terms of the claim that you were making before the court. Thousands, sometimes millions of dollars or millions of Uganda shillings, hundreds of millions of Uganda shillings. And the subject matter were cases like insurance, cases like serious commercial contracts. And part of the problem was the bulk of the kind of documents that had to be reviewed. Now, I am concerned about the absence of advocates because we considered the commercial court in Uganda as a training ground, apart from what we did in disposing of cases of a serious commercial nature expeditiously, because numbers were very important and we churned out numbers as commercial judges. But we were also interested in training advocates, because one of the complaints that people doing commerce in Uganda had was that our advocates were not at par with others in other jurisdictions in handling commercial cases. So we deemed it a responsibility of the court to train advocates, and no case would be filed without an advocate, because then it would not qualify to be a serious commercial dispute if a person could come to the court alone. And I thought that that was one of the things maybe we could take lessons from, that if it's a serious commercial dispute, then it must be handled seriously by advocates engaging at that level with the court and with the law. Thank you.
Thank you. One last, please.
Thank you. I am Emmanuel Gateretse, Chief Justice of Burundi. I have one question. My question is addressed to Honorable Lady Justice Paul Banyane from Lesotho. In my country, land cases are not received in cassation court. I want to know if the High Court of Lesotho, the cases treated by High Court of Lesotho are received in cassation court. This is my question. Thank you.
Thank you. I think time is not on our side, but the speakers have agreed to share with us their papers, and I'm sure they will leave behind their contacts, and we will continue to benchmark. Now, I would like to give you a last say. If you can spend 2 minutes each, we'll be within time. Could I begin with Lady Justice Polo?
Thank you, Chief
Yeah.
Justice. I'm sorry I didn't capture, I don't know what's happening with my ears today, but I didn't capture the question, what your concern is, Judge. May you please repeat?
My question is, are the land cases judged by the High Court of Lesotho received in cassation court?
I want to understand what your question is. The cases, the difference between the cases filed in the High Court and the Land Court.
In Burundi, the land cases arrived at the High Court. They are not received in cassation court.
How can I?
I think the best, we'll have a tea break and we will still be around for another 2 days. I think we can have some one-to-one exchange so that you get the paper.
Can I speak in French?
Okay. Do you have the one in French? Okay, we'll have one-to-one. We go to Lady Justice Charlotte Wezi Malonda.
Thank you very much, Lady Judge from Uganda, for your question. Indeed, when the move came to have specialized court, particularly the commercial court, in Malawi, we had special procedural rules for the commercial court. However, around 2017, there was a move yet again to have the same uniform civil procedural rules for all civil cases. So that's when we saw that other specialized courts were now adopting the commercial court rules as their own rules in terms of procedure. So looking at the issue of self-represented litigant, indeed it's an issue. I have myself dealt with several cases where a person represents themselves, and it's a very difficult case. You can actually see that a person is struggling to represent themselves. And even if you tell them to go find a lawyer, sometimes they can't afford. So yes, indeed, it's a learning curve. We will learn from other jurisdictions how they're handling it. And unfortunately, like I also said, when you have a commercial case, in most cases, you don't qualify for legal aid. So you still need to go and find a lawyer whom you can afford to pay to come and help you litigate your case. And the commercial matter is defined as it includes formation of governance of business in a commercial organization, a contractual relationship or commercial organizations, liabilities arising from commercial or business transaction, restructuring or payment of commercial debts, winding up of companies, bankruptcy, enforcement or review of commercial arbitration award, enforcement of a foreign judgment, supply or exchange of goods and services, banking, negotiable instruments, international credit, insurance services. And it's really a mouthful, and you really do find that self-represented litigants struggle when they come with their cases to the commercial courts. But unfortunately, our civil procedure rules do not compel them to come to be represented. And it's a learning curve, and it's something that we'll learn from other jurisdictions to see how we can improve, because at the end of the day, it's about access to justice. We don't want to have we want fairness in adjudication of our proceedings. We want the playing field to be leveled. So it's a learning curve, and we'll learn from that. Thank you.
Mr. Justice Matavele.
Thank you. Thank you for the comments and the questions. I don't think I was asked the specific question, but I can say that the experience of the Chief Justice of Nairobi is almost the same we have in Mozambique. As the Honorable Nyatima said yesterday, in Mozambique we have problems of terrorism in Cabo Delgado, and there we have children and the problems of registration of these children. To solve these cases, mobile brigades of civil registration staff were formed, and on the other hand, the Supreme Court created mobile courts for that place. These mobile courts leads not only with criminal cases, but also the jurisdiction of minors. So this is some challenges we have there, but we're trying to do our best so that we can provide accessible justice in this place. Thank you.
Mr. Justice Evaristo Pengele.
Thank you very much. The question by the CJ of Kenya, I hope our defense lawyers have not heard you, because they might raise a lot of constitutional issues and delay our cases. Most of the delays, I think, combined with what CJ Shivut asked, most of the delays were caused by these appeals against interlocutory decisions. So they would go on up to the court, up to the Supreme Court, and that would take a lot of years for the case to be sent back. So we have had jurisprudence, I think, as early as 1991, where the Supreme Court decided that there are no interlocutory appeals in criminal matters. But what some lawyers have been doing, they have been raising constitutional issues, especially after the coming into effect of the Constitution of 2016. They raise constitutional issues because the subordinate court and the High Court do not have jurisdiction to interpret the Constitution. So once they raise constitutional issues, automatically the case will go to the Constitutional Court. So, and what I've noticed, my lord, is some accused persons are interested in delaying the cases because they hope, they have an expectation that maybe as time goes, something might change. Maybe evidence might go missing, some witnesses might die, and maybe there might be change of regime and so on and so forth. So we have seen that has been really one of the inspirations for accused persons to delay matters. And my lord, there was a question on the form and substance and the corruption cases. For the Economic and Financial Crimes Court, there's it deals with corruption and also economic and financial crimes cases. So corruption is as defined under the Anti-Corruption Act of Zambia. Then for economic and financial crimes, there has been a definition given, which is, it means an omission or non-violent unlawful act by a person which leads or may lead to financial loss or illegal gain, either individually or in a group, in violation of the law governing economic activity in the Republic. So this has streamlined the cases that should go to the Economic and Financial Crimes Court. I hope I've dealt with all the issues raised.
Thank you very much.
Thank you.
Mr. Justice Gicheru.
Thank you, Chair. I think my presentation did not elicit any comment. Thank you, but I'm very happy to have been here with my colleagues here. Thank you very much.
Thank you very much. And the last chance goes to Lady Justice Susan Okalany.
My lord, I think
the same applies to me. I don't have anything more useful to add. Thank you.
I would like to also say nothing has come on my way other than a warning from the master of ceremony that we should not disrupt the coming session, which I would like to thank you for the confidence you have given us. Also the confidence you have given the speakers. They have given us excellent presentations. I hope we'll have more time to read. Thank you very much.
Let us give another applause to the panel and the chair. My Lord Chair, it was just a courtesy call. I didn't come to give a warning. I'm not competent. My Lords, Chief Justices, we are going to have a health break, and I will request that we do it short, just 25 minutes, so that we are back and we proceed with the next session. We lost 30 minutes, and we would like to redeem the 30 minutes to be in time for our lunch break. The afternoon, we have another session which will also lead us into the closing ceremony. So if we are able to redeem on the 30 minutes lost, that will be so wonderful. So my lords, I request that protocol will lead you for your health break, and may the good Lord bless it as we partake of it. Amen.
Distinct aroma of cooking with the taste of food that takes you on a journey. In the sound of homecoming and the sound of Mother Earth. In the magnificence we find on our travels and the exciting moments we experience. Ours is the kind of beauty that comes in all things big and small. All we have to do is awaken our senses and truly enjoy what's uniquely ours. Explore Uganda, the pearl of Africa.
Protocol, may I request that we usher in our principals so that we proceed with the next session. May we please return. Protocol, let us have the Chief Justices back in the hall so that we commence the next session. Mr. Martin Masiga, if you are in the hall, Mr. Martin Masiga of AJJF. Somebody would like to talk to you. Protocol, let us lead our guests to their seats. We want to redeem on time. It is 12:04. Mr. Martin Masiga, AJJF. If you are within the hall, please. Honorable Mr. Justice Oben S. Sebunja from Namibia would like to speak to you. Mr. Martin Masiga, AJJF. Honorable Mr. Justice Oben Sebunja from Namibia would like to speak to you. I will still remind us, St. John's Ambulance is still available for any medical attention. You could still take opportunity to visit. The doctors are ready to have you some checks and advice. This evening, we shall have a cultural gala, a gala dinner, and our dress code is cultural or traditional. And this will be at the poolside as you go down to the lake. You will be directed there should you not know the geography of this place. Our next session is going to be chaired by Honorable Mr. Justice Peter Chivute, Honorable Chief Justice of the Republic of Namibia. And at this juncture, I take the opportunity, my Lord, to invite you to the podium so that you can take us through the next session. My Lord, you're most welcome. Let us give His Lordship a hand clap as he takes the chairmanship of the session. My Lord, you're most welcome. Thank you.
Thank you, Director of Proceedings. The Honorable the Chief Justice of the Republic of Uganda, the Honorable Chief Justices and members of the Southern and East African Chief Justices Forum, Honorable and distinguished delegates, ladies and gentlemen, I'm honored to chair this critical discussion on reforming the selection and appointment of judicial officers in Southern and Eastern Africa. The appointment process plays a vital role in ensuring judicial independence, integrity, and public trust in our legal systems. Judicial appointments are significant for several reasons. They ensure that individuals of high competence, integrity, and independence uphold the rule of law and bolster public confidence in an impartial judiciary. The process by which judges are appointed is exercise. It's a crucial aspect of ensuring a fair, competent, and independent judiciary that serves all members of society. In Namibia, very briefly, we recently amended our Judicial Service Commission regulations to provide for public interviews of shortlisted candidates for possible judicial appointment, a move aimed at enhancing transparency and public trust in the appointment process. This approach aligns with the Lilongwe principles and guidelines adopted at the 2018 Southern Africa Chief Justice Forum, which promotes fairness and merit in judicial appointments, while also ensuring diversity on the bench. Earlier this year, I had the privilege of participating in discussions at the high-level roundtable in Johannesburg, where we explored the Constitution Hill Global Guidelines developed by the Institute for Integrated Transitions. These guidelines represent a set of best practices aimed at addressing the unique challenges faced by courts with constitutional mandates around the world, particularly in the appointment of apex courts judges. I will, however, refrain from going into further detail, as I'm certain that our esteemed panelists, Mr. Barney Afako, one of their panelists rather, will offer valuable insights into IFIT's work later in our session. And speaking of our panelists, it's my great honor to introduce our distinguished resource persons, being our next speaker and discussant. And at this point in time, I would like to invite the Honorable Mr. Justice Hilly Potani, State Counsel, to come forward, please. So Justice Potani, give me a round of applause as he's coming. Mr. Potani is a judge of the Supreme Court of Malawi. He is a seasoned member of the Malawian Judiciary, having joined in 1989. He has held various roles, including being the first deputy chairperson of the Industrial Relations Court and the registrar of the Supreme Court of Appeal and the High Court. In 2003, he was appointed a judge of the High Court of Malawi and was elevated to the Supreme Court of Appeal in 2020. Justice Potani, along with 4 other High Court judges, received the prestigious 2020 Chatham House Award in recognition of the professional manner in which they, as the Constitutional Court, handled the case challenging the results of the 2018 presidential election in Malawi. So you can actually refer to him as a towering judge. Quite literary, I think. Now, next, I would like to invite Mr. Barney Afako to join me on the stage, please. Mr. Afako, give him a round of applause as he's coming to join us. Mr. Barney Afako is an advocate in Uganda and has practiced law in Zimbabwe and the United Kingdom. He specializes in conflict mediation and has supported peace processes in countries such as Sudan, South Sudan, and Colombia. He is also a member of the UN Commission on Human Rights in South Sudan and serves as a tribunal judge in the UK. Additionally, he is involved in the Law and Peace Practice Group of the Institute for Integrated Transition. Now, each speaker will have about 15 minutes. And when you see me wave my notebook there, it means that there are 5 minutes left to your presentation. And I'm a very strict judge. I have that reputation. So please, I will not allow you to go beyond the allotted time. I'm joking, so don't. I'm very humble judge. Don't worry. Can I now? Very good. Just to again assure you that the interpreters are available. So the organizers have gone to greater lengths to provide for translations and interpretations. So please feel free to speak in your language for which interpretation is available. So don't feel constrained to speak in a language when you are not comfortable in. Can I ask now the Honorable Mr. Justice Potani, please, to take stage and make his presentation.
Thank you very much, Chair. Good morning once again. We are coming from a healthy break, and I believe that we are all energized for the last presentation for the morning. When the chair was introducing me, I thought he would add an addendum that on the way from Addis Ababa to Entebbe, we sat next to each other on the plane and we had a wonderful chat. My presentation, as it appears on the screen, is entitled Towards Reform in the Selection and Appointment of Judicial Officers in Southern and Eastern Africa. My Lord, our host, Chief Justice, the Chief Justice of the Republic of Uganda, my Lords, Honorable Chief Justice present here from the jurisdiction, from the various jurisdictions here present, allow me to stand on the protocols that have been established in the course of this gathering. I'll start my presentation by stating the very obvious, and this is that we cannot talk about governance without talking about judicial power, or judicial powers as it were. This takes me to what we all know, and this is the doctrine of separation of powers. This doctrine, as most of us know, was properly expounded by the ancient French jurist Montesquieu in his book, The Spirit of the Laws, way back in the 15th and 16th century. In short, the doctrine stipulates that the best form of government is one in which the executive, legislative, and judicial powers are separate and kept in check of each other to prevent any branch from becoming powerful, otherwise known as the tripartite system. I'm sure we all know, as basic constitutional law principles, how these three branches work and how they interdepend on each other in the running of government. This system of government is what most modern states follow to date. Now, coming to judicial powers, which is our main focus today, as we all know, judicial powers primarily entail the interpretation of various laws of the state. And Montesquieu defined a judge as, or a judicial officer as, the mouth that pronounces the word of the law. What this means is that a judge should not pronounce words that emanate from other sources. As a citizen, they can only be assured of the guarantee of their rights and freedoms if the court or the judicial officer is bound solely by the law and not other whims. I'll go further and state that the exercise of judicial powers is a daunting task, which requires a lot of care. You can see it there. You need to have great circumspection, which means it's a job that is delicate and that requires level-headedness. The demands of the judicial functions or judicial powers make it imperative that the appointment of judicial officers or the judicial officers must be well informed and must be through a process that is credible and impeccable. In my own jurisdiction, there's a section in the Courts Act, Section 34, which talks about the appointments of magistrates, which are judicial officers, which says they must be a fit and proper person. Somewhere in the Lilongwe principles and guidelines, a proper and fit person is defined, so to speak. Now, I would like to move on to have a look at the appointment process of judges in selected Southern and Eastern African countries. It seems there are 16 of them in this forum, but I've just singled out 10, or I've just singled out 10. Because of time limitations, I may not be able to go into each and every one of them. I'll start with South Africa. In South Africa, judges are appointed through a system that emphasizes judicial independence. And to that end, the Judicial Service Commission plays a vital role. Not any other organ, not any organ within the executive, but the Judicial Service Commission, which is supposed to be an independent organ, independent of the state or the legislature, of the executive or the legislature. The president appoints constitutional court judges, including Chief Justice and Deputy Justice, after consulting the Judicial Service Commission and leaders of political parties in the National Assembly. The rest of the processes are beamed there. I don't have to read through them in the interest of time. There's also the process in Zambia, which I'm sure is there, and hopefully you can read through as I'm rushing through, because I want to rush to the Lilongwe principles and guidelines, which are quite pertinent to our discussion this morning. It would be unfair not to talk about my own country, Malawi. Can you go down to Malawi? Yes. Judicial appointments in Malawi process is governed by the Constitution. It is the Judicial Service Commission that recommends to the president for appointment. And this is normally done after interviews, after advertisements have been flighted at the different media platforms, and people would apply. They are not interviewed. They are just screened through some mechanism, and then recommendations are made to the president, who does the final appointing authority. Significantly for the judiciary, the Chief Justice is appointed by the president, but subject to confirmation by a majority of members of parliament. Let's look at the case of, there's a particular case which I thought we should look at. Let's look at the case of Botswana and Lesotho and Namibia. Are we there? For Botswana, Lesotho, and Namibia. Let's start with Botswana. In Botswana, the constitution, as amended, this 1996 constitution, the appointments of the Chief Justice is under Section 96, and he is appointed by the president. The judges of the Court of Appeal and the High Court and the other judges are appointed by the president in accordance with the advice of the Judicial Service Commission, more or less like the Malawi scenario. The same seems to be the case with Lesotho, but in the case of Lesotho, instead of the president, it is the king, as we know, that is governed, is a monarch. But if you go through the different appointment process in the 10 countries at your own time, because they are all listed down, the 10 countries which I mentioned, there are some observations which I have made, and these are that evidently each country emphasizes a blend of executive involvement and judicial independence, with the commission, the Judicial Service Commission, playing a very significant and vital role in recommending or advising the president on the appointments. In the case of Malawi, it's a bit unique in the case of the vice president, in the case of the Chief Justice, where there is legislative vetting, and this adds a check not seen in most of the countries, because in most of the countries, there is no need for legislative confirmation. And across the regions, the Judicial Service Commission is an independent entity. Although sometimes some people have argued it may have some influence through its membership. In Namibia, the Judicial Service Commission has a broader representation from the legal community. In Malawi, we also have representation from the legal community, but it's just maybe one member of the legal fraternity. There are proposals in Malawi to broaden the composition of the Judicial Service Commission, and I think that is part of the reforms which we are undertaking, taking into account the concerns raised by various stakeholders. Now, we are talking about reform here at this conference as the theme of the conference. And on this aspect, I would like to take us back to the 2015 CEJAF conference, at which the chief justices in the jurisdictions in CEJAF decided to come up with some sort of a uniform or a general approach on the selection and appointment of judicial officers. Now, in the 2015 conference, the forum made a recommendation to have an ad hoc committee which would come up with the guidelines for adoption by the forum. A lot of groundwork was done in coming up with the principles, and it culminated in the endorsement of the principles and guidelines at the CEJAF conference of 2018, which Malawi, my country, was privileged to host, and I was in attendance at that meeting. I remember this issue took center stage at that meeting, and the drafted principles and guidelines were circulated to participants and scrutinized before adoption. In the consultation process, the guidelines and principles were guided by a research which was conducted, among others, by the Democratic Governance and Rights Unit of the University of Cape Town, and also international and regional declarations and instruments relating to judicial appointments. Now, going to the principles and guidelines, the overriding purpose of the guidelines and principles is to have best practices that would safeguard independence and integrity of the judiciary. The working group, in coming up with the principles and guidelines, made sure that they must come up with a process that will enhance public confidence and trust in the administration of justice. So there are several principles and guidelines, a lot of them. In fact, what you'd see there on the principles and guidelines is just an extract from the booklet, which contains the Lilongwe Principles and Guidelines of 2018. I don't know how many of us have had the opportunity to look at the document, but I would recommend that most of us, all of us rather, should acquaint ourselves with the document, especially those of us who sit in the Judicial Service Commissions in our respective jurisdictions. And I would also strongly urge all of us to mirror the principles and guidelines to our appointing processes and selection and appointment process, and see whether we are doing the right thing as per the guidelines and as per the principles and guidelines which are in the Lilongwe declaration, if I may call it. But just to give an overview, among others, the principles and guidelines demand that there must be transparency in the appointment of judges. I remember years back in my own jurisdiction, you would just hear that so-and-so has been appointed judge. Just on the radio. You wouldn't even know how it was done. You just hear the name. Maybe the only person who would be consulted is the appointee, would be the appointee. But I know that over time, the process has become a little transparent. As I said, they would normally advertise and people talk about it. But there's still a feeling, I believe I'm right on this one, that there's need for more transparency in the appointment of judges in Malawi, for example. The second principle is that I'm rushing through because of time, is that there must be independence of selection and appointing authority. Very obvious. So the person, the authority like Judicial Service Commission that makes the selection is supposed to be independent of any influence. It should not get names under the carpet from other sources. It should get the names through responses to the advertisements. Again, there's talk of fairness. I'm sure we know what fairness is. There are so many guidelines which come under fairness. You can look at them in detail at your own time. I have only 5 minutes to go. The appointment must be on merit. There are several things that are covered under merit. Then there's another point which is stakeholder engagement. I know, and I've heard that in some countries, there are public interviews. The chair here just mentioned that recently Namibia has adopted or has amended its provisions to provide for public interviews. In South Africa, it seems that's the case as well. I don't know which other countries conduct public interviews. It has its own disadvantages and its own advantages. Sometimes I'm told during public interviews, people ask questions just to embarrass you. They will go outside the realm of your functions. They will just ask you a question. Did you impregnate a girl when you were in standard 5? Something like that. And then the criteria, it's recommended that the criteria should be known. What are you looking for? Which qualifications? You are looking for somebody with a master's degree, a PhD, or a certificate in law, or what? Then there is the issue of fit and proper personal standards. This looks at issues like financial probity sometimes, and the whole history of the individual, whether they are fit and proper person to hold a judicial office. Then there's the issue of diversity. This is about, interest, should I say interest groups or backgrounds? You may have a country where maybe 90% of the population are Christians and you have 10% of Muslims. You may wish to consider including a Muslim on the bench as well, on the judicial office, to bring about diversity. The same talks about gender issues. Recently in Malawi, we are doing well. It seems there's a deliberate policy to bring on board as many ladies, women as possible to judicial office. Shortlisting, again, it must be a transparent way of doing it. And then the list goes on to vetting and stakeholder engagement. The vetting itself, sometimes you consult privately if you want. I know in Malawi, for example, sometimes they would consult very senior judges on the people who have shown interest. Then there's the issue of interviews and selection. In some countries, there are no interviews. They just look at the resume and maybe do the consultations behind the scenes. But I think maybe one-on-one interviews should be the way to go. So that maybe, among others, you can also see the demeanor of the applicant. Again, the decision-making process should be transparent as well. And talking about the appointment itself, the appointment must be formally made and in tandem with the Constitution. After the appointment, there might be need for induction so that the appointee settles down. You don't just throw him into water and say you will jump into the water and learn to swim. There's need for them to be properly trained. And then there is a guideline on applicability, which says that these guidelines should apply across the board for all judicial appointments, not just for judges, because we're looking at the judicial powers as a whole. Quickly, a conclusion. The process of appointment of judicial officers has a significant bearing on institutional independence of the judiciary and indeed the individual judicial officers' decision-making and determinations. There are principles and guidelines on the selection and appointment of judicial officers are a significant milestone by SEJAF. In fact, if SEJAF has done something which it will live to be remembered for, is the development of these guidelines, in my view. And I would implore all jurisdictions within the region to embrace these principles and guidelines or domesticate them in the rules and regulations that govern the appointment process in their respective jurisdictions. So really it remains up to the members of SEJAF to live up to these principles and guidelines by taking them on board, not simply paying lip service. Now, with your permission, my chair and the entire House, I have a burning issue which I want to comment on, not related to this presentation, but it's to do with the issue of funding for the judiciaries, which it seems every other judiciary is lamenting over. It has been talked about several times, and it seems all of us are not properly resourced by our respective governments. The suggestion I have is probably we could think of championing some sort of declaration to be made by our heads of state at an appropriate forum, whether it's SADC or AU, where they would say a threshold of the budget, say 3%, 5% of the national budget should be reserved for the judiciary. I know it has been done. It has been done in respect of healthy services, agriculture, and education in some countries. In Malawi, my Chief Justice, who was here at one time before he became Chief Justice, was chairing a budget and finance committee of the judiciary. And we tried to push that agenda. The executive was receptive. They said, we'll do it, but in phases until we get to 3% of the national budget. Mind you, we get less than 1% of the national budget as our allocation. So I thought I should abuse the podium and make that suggestion at this point. I want to thank you for your attention. I wish I had more time. Actually, I thought I had 30 minutes. I thought him would just be moderating, counsel from Uganda would just be moderating in a way. But anyway, I'm sure you can have time to look at the presentation when it's circulated at an appropriate time. Thank you so much. Asante sana, muito obrigado, merci.
Thank you, Mr. Justice Patani. Give him another round of applause, please. Now, I would like to call upon Mr. Fako. So to the discussant, please feel free to speak from wherever you are, wherever you may be seated or standing. I'm sure the audience will be able to see you.
Thank you very much indeed, Chief Justice, moderator. But first of all, Honorable Chief Justice of Uganda, our host, my lords, the Chief Justices present, other justices, I stand on the protocol already outlined. It is an immense honor and privilege to have been invited to participate in this august forum, and particularly to reflect on the presentation already made on reforms in the appointment of judges in our region. Mine is to bring some reflections that are within the Constitution Hill Global Guidelines that the Honorable Chief Justice of Namibia alluded to, and in which he participated in the adoption. So I want, by way of commenting on the presentation, to present these guidelines, which are guidelines on apex court appointments. Now, they're apex court appointments because it was recognized that every jurisdiction has its own procedures, processes evolving for the appointment of all judiciary. But what was missing globally was a set of ideas, if you like, guidelines on how apex courts, which are the courts that adjudicate on constitutional and the most important legal matters in every jurisdiction. So by way of definition, an apex court will be that court from which there is no further appeal on questions of the Constitution. But it also includes specialized constitutional courts, even where their decisions might go to another court, perhaps a Supreme Court like we have here in Uganda. So how did this process of identifying these guidelines come about? The Institute for Integrated Transitions, IFIT, which I'm representing today, embarked on a process of consultations, and it was triggered in Southern Africa. So it drew on the Lilongwe guidelines, principles and guidelines that we've just heard about, and it assembled a team of judges, jurists, academics, not only from the region, including Mr. Justice Moseneke of South Africa. It had contributions from across the globe, Latin America, Sri Lanka, Mexico, Tunisia, India, among others. But the guidelines, as they evolved, were also subjected to consultations, broad consultations. Hundreds of jurists, law schools, law firms were involved in critiquing them and making suggestions. So the outcome is truly globally consultative. But you will see, as I go through them briskly, that a lot of the principles are in fact already reflected in the Lilongwe principles and guidelines. In fact, if you like, they were a primer for the development of these global guidelines, which focus on apex courts. So what are the features of an apex court? First of all, as we said earlier, the exercise finality on constitutional interpretation. They deal with highly consequential social and political issues and often controversies within their particular countries. They also provide normative leadership within the justice systems. So on questions of interpretation, or on cases being heard, they rule on legislation, they rule on executive action, among others. In addition, they are also highly visible because of the nature of their work. They're highly visible within the country, not just within the legal system. And as a consequence, they experience greater political pressure and attempts to influence them. They also face a much higher degree of media and public scrutiny. And in this day and age, we might add social media to that. So for these reasons, because of their role, because of their visibility, because of the trust or expectation invested in them by the society, the process of their appointment is therefore particularly important. And the guidelines identify both individual and collective criteria of qualification. I'm going to invite all of us later to access the website of the Institute for Integrated Transitions, IFIT, and we'll make available the link for you to access these guidelines at your leisure. But in terms of the criteria, individual criteria and collective criteria, the individual criteria can be divided into two subcategories. Those are criteria that include, for inclusion, i.e., for qualification, which are based on character and merit, but also criteria for exclusion or disqualification of an individual from holding that office. So I'll go through those two broad categories in turn. In terms of individual criteria of inclusion, of course, we've mentioned and been discussing the question of integrity. It's obvious that judges must be of good character, composure, temperament, the ability to be calm under pressure, and often the pressure is immense, particularly when the cases attract strong public and political scrutiny. Another one is impartiality, that they're even-handed, open-minded, regardless of the party or the argument that is advanced. A fourth one is independent-mindedness. So they remain staunchly detached from pressure groups, either political, domestic, or foreign, and maintain that distance as they carry out their adjudication. We've been hearing over the case, over the last 2 days, the need for courage. So the willingness, I think there was a testimony from the Honorable Judge from Namibia whose judgment was being anticipated and articles were being published in the papers. So one needs courage, even in the face of blatant efforts to influence the decisions. And lastly, because of the way that these apex courts are not individual judge courts, they are panel-based courts, therefore, the need for collegiality, the way that decisions are made, listening to each other so that the plenary format works. So the individuals who would qualify for this role must also be able to work closely and respectfully with others while maintaining their independence. Now, there are 6 criteria of merit, and I'll simply list them. Expertise. They need to be on top of constitutional and particularly public law matters, and also the general area of law. In terms of merit, they must also be diligent. They must have intellectual ability. They should have the contextual, profound contextual knowledge of the country, of the region that they're adjudicating in. They don't simply rely on precedents from elsewhere without adapting them or critiquing them with that local and regional lens. They should also be inventive because often there are no clear precedents. So they should tease out the appropriate, they should be able to tease out the appropriate solutions, drawing on law context. And lastly, they should have prior experience in a professional capacity, not necessarily as a practicing judge, perhaps as a lecturer or scholar, and that can widen the scope from which one appoints to the apex positions. In terms of exclusion or disqualification, obviously, if there's a criminal record or if somebody has obvious conflicts of interest, then it may not be appropriate to appoint them. And in all jurisdictions, I believe there are age limits, often 70 in a lot of countries, but those can be a disqualification if a person obviously is over that age. Now, those are the individual criteria. There are also collective criteria of inclusion, because of course, these courts are a panel, viewpoint diversity. So we're careful not to appoint people who have the same perspective, culturally, intellectually, philosophically. Professional diversity, so maybe a balance between sitting judges, practicing lawyers, maybe academicians. In some jurisdictions, they don't necessarily draw from the legal profession, they draw from what we call law adjacent backgrounds. Demographic diversity, so that these courts reflect the nature of the society that they serve. We've already touched upon appointment procedures in the different countries of the region. The guidelines also recommend including lay persons in the process, not only legally qualified persons. Of course, in all jurisdictions, there's often political participation, and that may be from the executive. It could also be from the legislature. And these should also come with safeguards. The role of judicial service commissions, we've talked about, are very important. But on the transparency point, the publication of the guidelines and even the score sheet criteria for the final assessment is important, and it lends credence to the process, transparency and openness. And even with these bodies that carry out the shortlisting and appointment and assessments, it's important to have diversity as part of their constitution. And in the selection procedures, there is advice also on the nature of the deliberation, including if there are ties, how do you break a tie if individuals are evenly matched? And the process is not slavish towards points. In fact, it advises that we should be careful about scoring individuals who are being appointed, because the criteria are each unique, and it's a balancing exercise to have that balance between a numerative assessment, but also a holistic judgment of suitability and the context of diversity as well. There's a section which I will not go into on conditions of service and tenure, and you read it, that it's wrong on the fact that the judges should be well remunerated to reflect their standing, and there should be limitations on their terms based on age or a fixed period on which they can serve. All of these are suggestions drawn from different jurisdictions and are all for adaptation in each context. And so that is a quick run through of the guidance in the Constitution Hill Global Guidelines on Apex Court appointments. And to go back to the earlier point, these Apex courts were highlighted particularly as a focus of guidelines because of their importance in juridical leadership in the jurisdictions in which they serve. And I'm going to stop here so that I don't overshoot my time. Thank you.
Let's give him another round of applause. We will now return to the plenary, and I would seek the interventions of the plenary in the form of questions, questions, comments, and general comments. The floor is now open for us to interrogate the topic in greater detail, having listened to that very insightful presentations. The floor is now open. Anyone, please feel free. Don't, oh, is there a hand there? Oh, yes, please. There's a hand up there, please. If you may just start by introducing yourself and the jurisdiction you represent, please.
Justice Mulifi Magara from the Kingdom of Lesotho. What an illuminating and very thought-provoking presentations made. I will speak in relation to our situation in the kingdom relating to the appointment of judges and the composition of the Judicial Service Commission. It's a pleasure at this moment for me to share it with my colleagues that presently we are undergoing reforms regarding the composition of the Judicial Service Commission. I'm aware of what has been reflected here as the appointment scenario in my country. What we have done is to introduce reforms in such a way that the Judicial Service Commission will be broadly representative of all the materially relevant spheres of our society. We have, for instance, dispensed with the recommendation by the Prime Minister to the King about the appointment of the Chief Justice. This time, the Chief Justice shall be appointed directly by the King on the recommendation of the Judicial Service Commission, and not by the Prime Minister. We dispensed with that political aspect. Also, regarding transparency, presently, the current Chief Justice, the incumbent Chief Justice, has taken the initiative to introduce interviews which are witnessed by everyone, and in the process, the determination will have some basis. Now, on my personal view, in all fairness, I believe that however the JSC is comprised, whatever criteria is used for appointment, blessedly for me, I've never been part of the Judicial Service Commission, but from the conventional perspective, I believe that the word of the Law Society should be given substantial significance. Because as peers, we know who amongst us has prevalence over the operationalization of the substantive and the procedural dimensions of the law. We know who amongst us would be the best. So I would suggest that there should be an inclusion of the criteria in a way of a ratio percentage-wise, through which the word of the Law Society, the legal fraternity, would be given more consideration over all other opinions. Thank you. I think.
Thank you. Another hand up here. The Honorable Chief Justice of Botswana, please.
Thank you, Honorable Chair. Let me thank the two presenters for that very comprehensive and thought-provoking presentation. I must note that as we are from different jurisdictions, we are not at the same, we are not, I mean, we have developed at different paces from each other, and must note that setting up a proper and fair criteria for appointment of judges is not an event, but a process. So what needs to be done is to keep on improving, adapting from fellow colleagues, other jurisdictions, looking at the longer principles to come to try to improve our criteria. Where we are now, at least we advertise posts, we interview, but we don't do it through television. I mean, it's not televised. We do interview prospective candidates without necessarily televising. And we also advertise the availability of such posts. And I say, this is where we are today, but it's not like we are going to stagnate at that level all the time. We'll improve as time goes on. Let me conclude by asking one of the presenters, Professor Afoko, about, he talked about appointing judges for the apex courts who are necessarily from the legal background. We don't have the legal background in order to enhance professional diversity. He also mentioned that even lay persons could be appointed to the apex court. I wish I really heard you correctly. I'd like you to exemplify an appointment, a situation where you'll appoint someone who is not necessarily from a legal background, or someone who is a lay person to the apex court. Thank you.
But thank you. Can we take two more, if any, please? Yes, the Honorable the Chief Justice of Lesotho.
Thank you, Chair. I just wanted to say something on exclusionary factors that were mentioned by the second presenter. Just to say that in Lesotho, apart from criminal records, there's also a need for clearance by the tax authorities in order to prove that the candidate or applicant is tax compliant. Because in terms of our tax laws, it's a criminal offense not to pay tax. So we don't want to shortlist someone who's not tax compliant. Also, there should be a clearance by the Law Society, the Director of Public Prosecutions, and there's also one contentious one, security clearance. But normally, when in the JSC, we don't put much premium on that one because our experience is that these security agencies, sometimes what they present is not what you know about the candidate. I remember there's one candidate whom they said she was a security threat, but we knew her to be as innocent as an angel, and nothing so far has proven otherwise. So we went ahead, shortlisted her and appointed her. Thank you.
One last intervention, please. Oh, yes, the Honorable the Chief Justice of South Sudan.
Thank you. I don't know if I missed out. I just want to know if there is a provision about the gender issue. Because I know most men across the world are negative when it comes to this gender issue. And so when we are appointing judges, we should have very clear provision about the gender issue. Is it there in this thing? I missed out, I didn't get it. What do we do about gender to make sure that the women are well represented? Thank you.
Thank you. May I now ask respectively the presenters to react, to give their reactions to some of the issues raised. Anyone would like to go first? Honorable Just Potani.
Yeah, from Lesotho, I don't think there was a question as such. He only, not the CJ, the first judge, he just shared with us the reforms that are being undertaken in Lesotho, which is very commendable. He has mentioned that the reforms include broadening the composition of the JSC. What I would urge our brothers and sisters in Lesotho to do is to look at the guidelines and the principles and use them as a guiding tool in their reform process. Of course, you also mentioned of transparency and the Law Society having a louder voice or a bigger voice. I'm not quite sure if there was a question from the Honorable Chief Justice from Botswana, but what I heard him saying was that the appointment is not an event, it's a process. Indeed, it is a process. These days, it's a whole process. Like in my country, it takes quite some months, from the time the advertisements are flighted, then to the time you get the names out at the end of the day. Honorable Chief Justice from Lesotho, I may not have gotten your question, but I thought you just made comments. Lastly, South Sudan on gender. It comes under diversity. You remember one of the principles is that there must be diversity in the selection and appointment. And when you talk about diversity, it covers aspects like gender, race, culture, ethnicity, disability, geographical and regional representation, language, etc., etc. And for the case of Malawi, we have a Gender Equality Act, which gives proportions of how positions are supposed to be distributed in terms of gender in various public positions.
Thank you very much for those observations and questions. And I'll start with the last one, Honorable Chief Justice. South Sudan, yes, the global guidelines on apex court appointments also emphasize diversity and highlight gender and other attributes. And of course, these are only guidelines, and it may be that a country might want to even aim for parity and say that if half the population is female, then let's aim to reflect that in the judiciary. Some countries, I believe yours as well, has a 30-something% in the peace agreement. So there are different iterations of how to achieve that diversity of the bench. And it's important because in order to vest trust in the highest judiciary, citizens want to see themselves in that body so that they can trust and accept its judgments, even when it goes against them, because that is the critical test of trust. I think on the question, Honorable Chief Justice, on expanding, I'm paraphrasing this, expanding the participation on the bench to others beyond judges, to include people with a legal background and even lay persons. And I think these are reflections from, as I said, global experiences. There are some countries where you don't have to be a practicing judge or legally qualified to sit on the bench. You can be from an adjacent profession. You could be a lecturer, for example, in political science and an author and jurist. If you're deemed to have the competence on public law matters, you could then be appointed. But those are very specific to particular countries. We know that there are some countries that train their judiciaries, that you go to a judicial college to qualify to be a judge, and then you go through the ranks. So the different iterations on how to identify the most qualified persons, but we would suggest that the individual criteria are quite important. They're the baseline. Does the person fulfill those individual criteria in terms of their character and in terms of the merit that they bring, including their competence? And I think the question from the Honorable Chief Justice from Lesotho, the observations about criteria for exclusion, quite correct. The guidelines go into the question of the importance of vetting, and that for the apex courts, the requirement is even higher than for the lower courts. And the vetting process may also include information that comes to the selecting authority about the individual. So it's not just about the disclosures that an individual makes, but there are other ways of deriving information about their suitability. So it is suggested that the vetting process should include a financial audit of the candidates. That may also potentially include a psychological fitness test. We're going back to the individual characteristics of composure and even-handedness in the individuals who would sit on these apex courts. I think the rest were observations, and we agree with them. And I will simply conclude by saying that these guidelines emphasize the role of apex courts, because we're seeing that increasingly the role of these courts is critical for pacifying society, for assisting societies in transition and facing particular challenges, including of polarization.
Thank you. That concludes this session on the appointment, selection, and appointment processes in the region. Can you give a final round of applause to my presenters? And if you are so inclined, you may also clap for the chair.
Let us give another. And also our discussants and presenter. Thank you very much, my Lord Chief Justice and Chief Justices present. We want to thank the Lord for this far we have come, and we shall be breaking off for a lunch break. And strictly, we are going to use 1 hour so that we are able to return for the afternoon session. It's just about 13 minutes past 1. If we can use just those remaining minutes to 2, that would be so great. Our lunch is at the Sunset Restaurant. That's where we had our lunch yesterday. And I'll request protocol to move us first so that we are able to have the lunch ready. This evening, we shall have our gala dinner. The Ugandan delegation, you are the hosts. So please, the dress code is cultural or traditional wear. Let us come together and we showcase our cultures, our traditions, so that our visitors can choose to stay with us. Yes, we have to show them something nice, entice them to remain behind. Yes. So, protocol, please, we shall be breaking off for lunch. Mr. Martin Masiga, AJJF, please Honorable Mr. Justice Oben Sibenja from Namibia would like to speak to you. Thank you very much, and let me pray for the food. Lord our Father, we thank you for today. We thank you again for taking us through this session, and we want to thank you for the food that you have provided for our health. Lord, bless it and bless all the people who are going to partake of it. In Jesus' name we pray. Amen. Bon appetit. Thank you.